Hello and welcome to the Kenneth for Kamen Lawcast, the NJ Laws Tube, looking at recent cases by the appellate courts and Supreme Court. In this edition, we look at State versus Schmidt, where the court held that if there's not enough breath supplied by a drunk driving suspect on the Alcotest, the officer must read additional warnings. In this opinion, the court held that 1. The police are required to comply with N.J.S.A 39:4-50.2e by reading the standard language concerning the consequences of a refusal to take an Alcotest, which is part 2 of the standard statement. Where a defendant unequivocally agrees to submit to an Alcotest, but then fails without reasonable excuse to produce a valid sample, and 2. The police have the discretion to discontinue the Alcotest and charge the arrestee with refusal without affording the arrestee the maximum 11 attempts that the Alcotest machine permits. Therefore, let's say someone is arrested for DWI. They say, I'll take the test. They can't give enough air for whatever reason once they're at the machine. The police officer must read the consequences of refusal, which is part 2 of the standard statement. If they do not, then they cannot be convicted of refusal. And that's State versus Schmidt. 194 N.J.S.A 214 Appellate Division 2010. For information on other refusal and DWI cases, visit website njlaws.com. That's njlaws.com, or website benotguilty.com. That's benotguilty.com. For other information, contact the Law Office of Kenneth for Kamen, 732-572-0500. Thank you and good luck.